Legal English homework for Legal Eagles about the servitudes. You have found a beautiful property which you would like to acquire and build a house. There is only one problem. Your future home may not have access to the main road because it's a landlocked property. Is it already disqualified and you have to find another one? My today's seminar addresses the issue of easement by necessity, the possibility to make your dream come true. Easement by necessity falls under the heading of servitudes, which are one of the categories of limited property rights. Sounds complicated? Let me clarify. Generally speaking, servitude is the legal right to use part of the other property. It is important to note that the servitudes may encumber only immovable properties. Does it mean that the problem is solved? May you knock to your neighbor's door and ask him to grant you an easement? Not so fast. Firstly, you have to examine whether your property meets the conditions to be a dominant immovable property. I refer to Article 145 Polish Civil Code. The crucial test for determining whether it is possible to grant an easement by necessity is to find if your property does not have proper access to the public road. The easement by necessity may not be established if there is a possibility to reach the property by the existing roads, but the owner finds it difficult. For example, the dirt road. If the property meets a requirement to be landlocked, then it is possible to seek an easement by necessity. Obviously, nothing for free. The owners of the encumbered immovable properties may demand remuneration. Okay, the first step has been made, but what's next? This brings me to the issue of exercise the easement. The easement by necessity shall be exercised in such a manner as to make the use of encumbered immovable property the least difficult possible. But what if the circumstances change and the servitude is for the owner of the encumbered property particularly onerous? I have to make a distinction between the situation when the servitude is not necessary for the proper use of the dominant immovable property and when the servitude has lost any significance for the dominant property. In the first case, the servitude may be lifted for remuneration, whereas in the second case, the servitude may be even lifted without remuneration. You have to be also aware that the servitude may expire as a result of non-exercise for 10 years. Last but not least, the easement by necessity is a prospective easement, which means that it may be acquired in the case when the party made use of a permanent and visible installation for 20 years in a good faith or 30 years in a bad faith. I believe I have dispelled your doubts. If not, do not hesitate to contact me.